today, and thank you for taking your eyes away from the drama that's going on in another part of this campus right now with the impeachment proceedings or the trial. My name is Sarah Stern. I'm the founder and president of Endowment for Middle East Truth, and it's a real pleasure and honor to welcome you to this very, very important event. On November 18, 2019, Secretary of State Mike Pompeo made a quite remarkable announcement by saying, U.S. public statements on settlement activities in the West Bank have been inconsistent over decades. In 1978, the Carter administration categorically concluded that Israel's establishment of civilian settlements was inconsistent with international law. However, in 1981, President Reagan disagreed with that conclusion and stated that he didn't believe that the settlements were inherently illegal. Subsequent administrations recognized that unrestrained settlement activity could be an obstacle to peace, but they wisely and prudently recognized that dwelling on legal positions didn't advance peace. However, in December 2016, at the very end of the previous administration, Secretary Kerry changed decades of this careful bipartisan approach by publicly reaffirming the supposed illegality of settlements. After carefully studying all sides of the legal debate, this administration agrees with President Reagan. The establishment of Israeli civilian settlements in the West Bank is not per se inconsistent with international law. So this actually is a very, very important statement, and I'm proud to tell you that we are the first think tank and policy shop on this side of the Atlantic to actually discuss this very remarkable statement. And that's basically one of the reasons why EMET was created, to try to challenge some of the tired, stale, old conventional wisdom, and to think about whether or not that old conventional wisdom has actually brought us any closer to the objective of peace. And here to discuss these issues, I am honored to tell you, are probably three of the most preeminent international legal scholars in the world. Doug Feith is a senior fellow at the Hudson Institute, where he heads the Center for National Security Strategies. He's the author of the New York Times best-selling memoir, War and Decision, Inside the Pentagon at the Dawn of the War on Terrorism, published in 2008 by Harper. He was a professor of national security studies at Georgetown University School of Foreign Service, a distinguished visiting fellow at Stanford University's Hoover Institution, and a visiting scholar at Harvard University's Kennedy School of Government. Now, I can't read the entire bios of any of these illustrious individuals because it will take me the entire time that's allotted. Just suffice it to say that Doug's writings have appeared in the New York Times, the Washington Post, Commentary, the Wall Street Journal, Foreign Affairs, and multiple other publications. Professor Avi Bell is again among the world's leading scholars of international law, economic analysis of law, property and intellectual property. A professor at the University of San Diego School of Law, at Bar-Ilan University's Faculty of Law. Avi also serves as a senior fellow at the Kohelet Policy Forum and is dean of the Tikva Summer Institute, Law, Governance, and the Foundations of Democracy in an International Perspective. He's also a visiting fellow at the Project on the Foundations of Private Law at Harvard Law School, a visiting professor at the law schools of Fordham University and the University of Connecticut, and is director of the global law firm at the Jerusalem Center for Public Affairs. He's received, both of you have received your BA and your JD from Harvard, your JD from Georgetown, BA from Harvard. You received your BA with honors from the University of Chicago and your doctorate from Harvard, and you have published very far and wide. And Eugene, Eugene Kontorovich is a professor at George Mason Antonio Scalia School of Law and the director of its Center for International Law in the Middle East. Before coming to George Mason, he had been a professor at Northwestern University School of Law for 11 years, an expert in international and constitutional law. He has published over 30 academic articles in the leading law reviews and peer-reviewed journals. His scholarship has been cited in leading international law cases in the U.S. and abroad. He is the head of the International Law Department at the Kohelet Policy Forum, the only other institution to have a seminar such as the one we are conducting today, which is a Jerusalem-based think tank and is recognized as one of the world's preeminent experts on international law in the Israel-Arab context. An author from Haaretz had said, and Haaretz is not exactly a right-wing newspaper, he has, quote, emerged as a one-man legal lawfare brain trust for the Jewish state, and he is one of the cagiest commentators. So, and of course, Eugene has published far and wide, and he has written just 2 recent articles for the Wall Street Journal about this issue, and another one about Human Rights Watch, and how they are not quite as objective as they pretend to be. We're going to start with Doug, who is going to give us a fundamental historical background of these legal issues, and then we're going to go to Eugene, who's going to talk basically about the ramifications of this statement, and Avi has the illustrious job of doing all the cleanup of whatever's left after this. Okay, so Doug, take it away.
Thank you, Sarah, and thanks to EMET for organizing this panel. It's nice to be here to talk with you. And as Sarah said, my role is to help define some terms and to provide some historical context. Palestine is, let's start with the most fundamental definitions. Palestine is a region that Christians commonly call the Holy Land. Jews traditionally call the land of Israel. The West Bank is the area within Western Palestine that Jordan conquered in the 1948-49 war and then lost to Israel in the 1967 war. Jews have lived in Palestine since the days of the Bible. The Romans called the land Judea and then changed its name, which is how it came to be known as Palestine. Now, the land was conquered many times. No need to go through the very long list of invaders. But for our purposes, it's enough to note that the Turks conquered it in 1517. They owned it and the surrounding territory for 400 years. And throughout that period, Jews lived in Palestine, including in what is now called the West Bank. Then in World War I, and for history students it's a gift, precisely 400 years after the Turks conquered it, in 1917, the British conquered it from the Turks. In that war, Palestine was among the enemy lands that Britain conquered. The British then ruled Palestine for 3 decades until 1948. And in that period, they banned Jews from settling in eastern Palestine, but they allowed Jews to live anywhere in western Palestine, including the area now called the West Bank. In 1948, Britain relinquished control over western Palestine. Israel declared independence. Its Arab neighbors then launched a war to destroy it, and in that war, the Kingdom of Jordan, which was at the time known as the Kingdom of Transjordan, conquered the West Bank and claimed to annex it. Jews were no longer allowed to live in the West Bank. But 19 years later, in 1967, Jordan joined another Arab war against Israel, and in that war, Israel conquered the West Bank. Jews then created the various towns and villages that are commonly called settlements. and are our subject here today. So for thousands of years, Jews could and did live in the West Bank, a part of the ancient Jewish homeland. From 1948 till 1967, Jordan prohibited Jews from living there, and for the last half century, Jews have been living there again. Yet President Jimmy Carter's administration decided that the anomaly was the norm. It asked itself whether Jews should be allowed to live in the West Bank, and it chose to find the answer not in the broad sweep of history or in a comprehensive legal analysis, but in the odd 19-year period when Jordan banned Jews from living in the territory. Herbert Hansel was the legal advisor of the State Department in the Carter administration. And in 1978, he wrote a letter to members of Congress saying that the Jewish settlements in the West Bank were inconsistent with international law. This was the first time that the US government officially made that assertion. In 1981, as Sarah mentioned, President Ronald Reagan said he disagreed with the Carter administration and did not believe the Israeli settlements were illegal. For the next 25 years, US governments refrained from calling the settlements illegal. Then, in its final weeks, the Obama administration voted for a UN Security Council resolution that condemned Israel on many grounds, including that its West Bank settlements are a flagrant violation under international law. Finally, this past November 18th, again as Sarah mentioned, Secretary of State Mike Pompeo delivered his prepared statement criticizing the Obama administration for reviving the denunciation, as he put it, of the supposed illegality of settlements. This administration agrees with President Reagan, Secretary Pompeo said, adding, the establishment of Israeli civilian settlements in the West Bank is not per se inconsistent with international law. Okay, that's a quick bare bones review, and I'll flesh out a few points. First, let's focus on this 1978 Hansel letter. It's important because it's the only thing that passes for a legal analysis supporting the assertion that the settlements are illegal. The first major problem with the letter is that there are two major sources of Jewish and Israeli rights in the West Bank. The first is the 1922 Palestine Mandate. The second is the 1967 war. But Mr. Hansel addressed only the second of these. Now, what was the 1922 Palestine Mandate? After World War I, the Allies, who won the war, could simply have annexed the lands they won in the war. That would have been in line with long-established principles of international law regarding conquest. But, embracing the progressivism of the age, and in the service of liberal principles of democracy and self-determination, the Allies decided not to annex any conquered lands. They immediately recognized some of those lands as independent nations, and they decided that those that were not yet ready for independence would be held in trust for the people who would someday achieve independence there. The trusts were known as mandates, and the trustees were known as mandatories. The mandate for Palestine applied to the land on both sides of the Jordan River. The eastern part of Mandate Palestine, known as Transjordan, is now the Kingdom of Jordan. The western part of Mandate Palestine is now Israel, Gaza, and the West Bank. Britain was Palestine's mandatory. The mandate in its preamble recognized the historical connection of the Jewish people with Palestine and the grounds for reconstituting their national home in that country. Reconstituting was a word that was much fought over when they were drafting the mandate. It was considered a highly significant term by the Zionists, pushed very hard to have that included in the mandate, and it wasn't included. Article 2 stated the mandate's main purpose. It was to secure in Palestine the establishment of the Jewish national home. A few weeks after the League of Nations approved the mandate, Britain excluded Eastern Palestine from the Jewish national home, but not any of Western Palestine. That was in 1922. Article 6 of the mandate required the mandatory to encourage close settlement by Jews on the land. Again, this applied to all of Western Palestine. Here's something important to note. The mandate spoke of the Jews' right to reconstitute their national home in Palestine, but the Allies did not presume to grant that right to the Jews. Rather, they made a point of specifying that the right derived from history, from, quote, the historical connection of the Jewish people with Palestine. Right? So they didn't say, we, the British, conquered the land, and we give the Jews the right to set up a home. They said, we conquered the land, and we recognize the Jewish right to reconstitute its home based on the historical connection of the Jewish people with the land. That historical connection is the source of Israel's right to exist. It's also the source of the Jewish people's right to close settlement on the land, including the West Bank. When David Ben-Gurion in 1948 proclaimed Israel's independence, he relied on that historical right. He said, the right of the Jewish people to national birth in its own country was reaffirmed in the mandate of the League of Nations, which in particular gave international sanction to the historic connection between the Jewish people and the land of Israel, and to the right of the Jewish people to rebuild its national home. The Carter administration's Hansel letter acknowledged that the armistice lines drawn after Israel's War of Independence were not borders, but merely de facto boundaries, which is a quote from the Hansel letter. Because the war against Israel in 1948 and 49 was a war of aggression, the United States never recognized Jordan's annexation of the West Bank. Accordingly, the Hansel letter noted that Jordan did not have legitimate sovereign rights in the West Bank. So that was also noted in the Hansel letter. Yet, the letter illogically implied that Jordan's period of illegal occupation canceled the mandate-recognized right of Jews to live in the West Bank. The letter said that Israel was in the West Bank solely as a belligerent occupier, and as such had no right to create Jewish settlements there. But it completely ignored the rights of the Jewish people under the Palestine Mandate. Now, I'll leave it to Eugene Kontorovich to explain, I hope he will, what's wrong with the Hansel letter's argument that Israel's status in the West Bank is that of a belligerent occupier. Israel's West Bank settlements are controversial for many reasons. One can make practical policy arguments in favor and against them. And debating whether they serve Israel's security interests and whether they advance or hinder the pursuit of a consensual peace. You can debate all that. I'm not addressing any of those arguments today, but I want to explain why Israel's enemies have always ascribed enormous importance to denouncing the settlements not just on policy grounds, but as illegal. The reason is that the legal basis for the settlements is the same as that of the state of Israel itself. It is the 1922 Palestine Mandate, and its recognition that Jewish rights to a national home in Palestine derive from the historical connection of the Jews with that land. The settlements may be wise or unwise, good or bad for security or for peace, but attacks on them as illegal serve to undermine the legitimacy of Israel. And that's why Israel's enemies have made such a point of asserting that the settlements violate international law. As I mentioned, when Ronald Reagan became president, he said he didn't think the settlements were illegal. Now, I worked for him at the time. I was a young Middle East specialist on the National Security Council staff. And I was asked to write a brief memo on the subject for the president. And this is what the memo looked like. This is from the Reagan library. And I'll read you the memo. The subject was Notes on Legality of Israel's West Bank Settlements. The date is June 16, 1981. In February 1981, President Reagan noted that the Carter administration had labeled the settlements illegal. President Reagan observed they are not. The settlements are legal, but the issue is properly a political question, not a legal question. The U.S. government has recognized no country's sovereignty over the West Bank since Britain controlled the area under the Palestine Mandate. The issue of sovereignty is open and will not be closed until the actual parties to the conflict formally consent to a peace agreement. In the meantime, there is no law that bars Jews from settling on the West Bank. No one should be excluded simply on account of his nationality or religion. Officials in the administration today knew about President Reagan's position and my memo to him, and I was pleased that Secretary Pompeo, in discussing the matter, noted that President Reagan didn't believe that the settlements were inherently illegal and declared, "This administration agrees with President Reagan." Secretary Pompeo aligned himself with the Reagan administration and its successors. As Sarah read, that the Reagan administration and its successors that wisely and prudently, as Mr. Pompeo put it, recognized that attacking the settlements as illegal didn't advance peace. The political context for this issue, what's the broader political context for this issue? It's the effort by Israel's enemies to destroy Israel. An important part of that effort is ideological warfare. And important in that ideological war are the arguments that Israel is vulnerable because it is illegitimate, not morally confident, not deeply rooted in the land, not closely attached to its friends. So long as those enemies view Israel as vulnerable, so long as they think they can someday defeat Israel, there will not be a consensual peace. What the current U.S. administration did with its announcement about the legality of the settlements was to reinforce important messages. That the U.S. is closely attached to Israel, and that the historical connection of Israel with the land is strong and significant. Those messages have been reinforced by other administration actions too, such as the move of the U.S. Embassy to Jerusalem, the recognition of Israeli sovereignty over the Golan Heights, and by U.S.-Israeli defense and intelligence cooperation. So to close, I want to reiterate a point I made in a recent article I wrote. In the despair of the anti-Israel eliminationists is the best hope for a negotiated peace.
Eugene?
Thank you all for being here, and it's great to be on a panel with Doug and Avi, who have done so much to bring this outcome to pass. When the administration announced that it does not view Jews living in those areas of mandatory Palestine from which Jordan had ethnically cleansed the Jewish population in 1949 as being illegal, they did not provide a detailed statement of the reasons for doing so, or a detailed legal analysis. That's appropriate. It was an announcement of a policy decision that had a legal background, but it was not itself a legal memo, and that's as it should be. But it's important to understand that there are indeed powerful legal reasons for the administration's conclusion, and in particular, that the Carter administration's Hansel memo was quite poorly grounded in law. I think the most amazing thing about the Hansel memo is how short it is. It's 4 pages. It's a short 4 pages, which goes in huge, broad brush sweeps across major issues, completely neglects to discuss very basic and major issues, and you know, if I was a law professor who assigned a memo in 1967 on the legal status of the territories, and that's what I got, it would not have been, I think, an A paper. The entire analysis of the legality of settlements is based on the application of the Fourth Geneva Convention, Article 49, paragraph 6, which provides that an occupied power shall not deport or transfer its population into the territory it occupies. Now, leaving aside the point that it's far from clear what those words mean, and there are no precedents for understanding what they mean, or at least the precedents point the other way. The Hansel memo did not look at how those words had ever been interpreted in other contexts, for example, in the US occupation of Berlin, which was ongoing at the time, where nobody seemed to regard the American occupation as any kind of barrier to Americans moving to West Berlin. So he didn't discuss any precedents, any application. He assumed it meant what he wanted it to mean, and we're not going to discuss what it actually does mean, because the first question is, why are we talking about Article 49.6 of the Fourth Geneva Convention? What relevance does it have? Why do you get to what hat did he pull it out of? And it's important to the Fourth Geneva Convention is formally known as the Geneva Convention of 1949 relative to the protection of civilians in times of war. That's very important. It is not like 10 Commandments, rules for all time. Right? It is not the Universal Declaration of Human Rights, or other, the Genocide Convention. So when are you not supposed to, according to the genocide, when are you not supposed to have genocide? Always, right? There's never a time for genocide. But the Geneva Convention is not a set of rules for all time. It's rules about very specific situations. And that is a situation of war in between states. In particular, Article 49 deals with a part of war that is called occupation. But occupation only arises in the context of a war between two countries, and then only lasts as long as the war lasts. So you don't read Article 49.6 unless there is a belligerent occupation in time of war. You need a war for a belligerent occupation. So what is a belligerent occupation? A belligerent occupation is when one country occupies the territory of a hostile country. When it occupies hostile territory. Not even foreign territory. And this is an important caveat that's made actually quite clear in the recent edition of the Defense Department Law of War Manual. If an army in a war between two countries, let's say between 3 countries, takes territory belonging to an allied country, a co-belligerent, that had been under the control of the enemy, even putting under your control territory of a co-belligerent does not result in an occupation. When you take territory belonging to an enemy country. So, is that recipe? So what does not count as occupation? For example, as the Defense Department Manual makes clear, putting under your control co-belligerent territory of a friendly country, and certainly putting under your control your own territory. So, and imagine you have a situation in which a country has a certain piece of sovereign territory which it never actually managed to fully control. Because during the War of Independence, that territory was occupied by another country. So it never, it was formally within the borders of the first country, but that first country never enjoyed control because of the occupation of another country that was coterminous with its independence. And after 19 years of unquestioned de facto control, occupation, by the second country, in a surprise development, the first country manages to secure some of the territory and push them back, retake some of their territory. Would we call that an occupation? Would anyone call that an occupation? And it's not a hypothetical question. It's really, it's actually a question to which we have an answer. Because this is what happened 2 years ago when the Republic of Azerbaijan managed to push back the forces of Armenia beyond the prior armistice line of control in Nagorno-Karabakh, making not sort of historical, earth-shaking, miraculous gains as in 1967, but pushing the Armenians out of certain areas of Nagorno-Karabakh, which was territory within the borders of Azerbaijan that they had occupied in the circumstances I have described. I'm not aware of a single authority who has described that those territories coming under Azerbaijani control as now making them subject to Azerbaijani occupation. And Azerbaijan is now required to prevent any of its nationals or citizens from moving into that territory. One can imagine a hypothetical, and it's very hard to imagine because it takes miracles, but not everyone enjoys the benefit of miracles. You can imagine if in 14 years, Ukraine would dislodge Russia from Crimea. Would anyone say, okay guys, you can hold on to it, but you have to make a moat and prevent Ukrainians, including those who fled from that territory, from moving back to it. That would be absurd. Okay, and that is indeed exactly our scenario. Because when the state of Israel was created, what were its borders? And Professor Bell, Avi, and I have a paper about this. Why does the world regard Nagorno-Karabakh as being occupied Azerbaijani territory? It is not because most of the people who live there are ethnic Turkic-speaking Azerbaijanis, in fact, or Muslims. In fact, the majority of the people were ethnic Christian Armenians, Eastern Orthodox Armenians. Is it because it had always been part of Azerbaijan? No, not really. It had been under a variety of regimes and was historically, at various points, part of an Armenian kingdom in the Middle Ages and prior. Why is it regarded as part of Azerbaijan? Because it was part of the Soviet Socialist Republic of Azerbaijan within its borders. And when a new country is created, it inherits the borders of the prior top-level administrative unit in that territory, in all cases, even when there are ethnic minorities there that may not be happy about it, which is pretty much all of the time. Because political borders never perfectly map ethnic borders, because human population distributions are scattered and not uniform, and very hard to capture through just lines. Of course, so when Israel was created, what were the boundaries of the last top-level administrative unit there? Those were the boundaries of mandatory Palestine, which of course included Judea and Samaria. So when Jordan seized control of these areas, they were clearly not part of Jordan. It's undisputable. The Hansel Memo does not dispute this. They were not part of Jordan. And indeed, one could argue more strongly that they were territories to which Israel had a sovereign claim. In which case, you cannot self-occupy. You cannot occupy your own territory. It's not even clear if you can occupy territory that belongs to no sovereign, because the Geneva Conventions is a treaty between countries. Right? It protects the signatory parties. You have no protection as a Geneva Convention signatory from having the territory that is not yours be occupied. Right? You cannot complain about the occupation of territory that is not yours. So there was not an occupation from the get-go. That doesn't mean it did not come under Israeli military force, but occupation is a very particular legal status that requires certain ingredients that weren't met. And it takes much more, not just a military government. So there was not an occupation ab initio. And thus, we don't need to open up the Fourth Geneva Convention and see what it says about occupation, because the requirements of the Geneva Convention for the realization of an occupation were not met. But the Geneva Convention doesn't just define when an occupation starts, it also defines when it ends. Right? The Geneva Convention has several provisions governing when the applicability of the Geneva Conventions ends. When, if you have to come to open up the Geneva Convention, and indeed the Fourth Geneva Convention was, in parts, applicable to this conflict. There was a conflict between two contracting parties. Even if there was not an occupation, other provisions of the Geneva Convention did come into force. When does the application of the Geneva Convention end? So Geneva Conventions don't just end when the shooting stops. Right? They continue to apply if there's occupation or a state of hostilities after kinetic hostilities stop. But the Geneva Convention does come to a full halt if both actual hostilities come to an end and de jure hostilities come to an end. In other words, when peace is made. You don't read the treaty about war when you have peace. Right? The treaty about war does not survive peace. And there is no case in which a good faith, i.e. non-coerced, peace treaty has been thought to not terminate the applicability of the Fourth Geneva Convention. So, for example, when the United States made peace with Federal Republic of Germany, made a treaty with the Federal Republic of Germany, after that treaty terminated any state of belligerence that could exist between the Allied powers and Germany, such that the continued presence of Allied troops, who had been there since 1945 in Germany, were no longer an occupation. Germany was occupied, and then it wasn't occupied because of the peace treaty, not because the troops went away. The same number of troops were there, more because of the Cold War. Similarly, America makes a treaty with the new government in Afghanistan, after the invasion of Afghanistan, the post-Taliban government. There is no longer a state of hostilities between Afghanistan and the United States. So even though there's still lots of U.S. troops there, and the U.S. might call the shots in various ways and have great say in what happens, there is not a state of occupation. Now the amazing thing is, the Hansel memo was fully aware of this point. And Herbert Hansel wrote, there is an occupation. He was wrong about that. But then he said, of course, if the occupation were to end because a peace treaty would be signed with Jordan. If the parties sign a peace treaty, then we can close this up. Now, that was, of course, before they knew that in 1994, a peace treaty would be signed with Jordan. I don't know if he would have acknowledged that had he knew how the story ends. You can only really know what people honestly think if you, ask them what the rule is before they know how the game ends. But in fact, an unconditional peace treaty was signed with Jordan in 1994. That terminates any state of belligerence. So even if the Hansel memo was, first of all, the Hansel memo was wrong. But even if it was right, and by its own terms, there could not be any state of occupation after 1994, which makes any provision of Article 49, occupation provisions, moot. So there are a lot of people who say they believe in the Hansel memo. Say, oh yeah, the Hansel memo. Hansel memo is right. It concluded settlements were illegal. But they don't seem to acknowledge that if they like the Hansel memo, they themselves have to acknowledge that the settlements today are legal. So nobody really believes in the Hansel memo, it seems. So either way, and I think that's also just a very good example of the sort of results-oriented, bottom-line nature of international law arguments here. That people often cite the Hansel memo for the proposition settlements are illegal. It didn't say that. It said at the time, under the current circumstances, the legal advisor believed settlements to be illegal, and now he would believe them to be legal. But that involves some application of the reasoning, which people don't seem to be actually interested in, only in the bottom line. So either way you have it, whether you like the Hanselman or you don't, whether it was right or wrong, today, by all views, presence of Jews in these places should not be considered as being legally problematic.
Thank you. It's a great pleasure to be here, especially with this illustrious set of people in the panel. I'd like to talk to you about a gentleman that I've never met. His name is Issam Akel. Issam Akel is an American citizen, a Palestinian, who at least in 2018 had been resident for a number of years in the old city of Jerusalem. Now, at some point in 2018, he was in Ramallah. I think he was doing some shopping. He was arrested by Palestinian police. He was put in jail for the crime of selling land to a Jewish organization. He was put on trial shortly after Christmas in 2018. He was sentenced to life in prison with hard labor, that is, to a labor camp for life, for this crime. Again, the crime of selling land willingly that he owned to a willing buyer who happened to be Jewish. After he was sentenced and held in jail a little while longer, the Palestinian Authority yielded to the request of the United States to have him released. And he was released from jail. I don't know where he's located now. I don't know whether he feels safe living in Jerusalem still. I never, as I said, I've never met the gentleman. Now, Issam Akel is obviously not the only person to whom this has happened. Under the law of the Palestinian Authority, to the extent that we can say that there is an orderly legal process in the Palestinian Authority, it is a crime to sell land to Jews. It's described actually as several different crimes, mostly along the lines of treason. The punishment for selling land to Jews is up to and including death. The death penalty has been imposed. These days, Mahmoud Abbas, the president of the Palestinian Authority, now in the 16th year of his 4-year term, has decided that it's probably poor public relations to execute people for selling land to Jews. And so several years ago, he instituted a policy of, after having the sellers arrested and tried and sentenced to death, he would commute their sentence to years in labor camp. Generally life, sometimes as little as 10 years in labor camp. And that seems to be the general pattern now, that they'll be sentenced to, if they're sentenced to death, commuted to labor, or they're just sentenced straight to life of hard labor. Why is all this important? This is the background that you have to understand when anybody talks about settlements. And it's the background you have to understand because, especially when they start talking about law and settlements, what does international law have to say about settlements? What do the treaties, what's the Fourth Geneva Convention say about settlements? What is, I don't know, that the regulations attached to the Hague Conventions of 1907, what do they say about settlements? Does anybody here know? What do they say about the word settlement? Nothing. Nothing. Settlement's not a legal term. It's a term that you'll see all the time in media reports. The international community considers Israeli settlements to be illegal. Well, they may. I don't know how to go to the international community to get a quote. If that's in fact their opinion, but let's presume that it is. There is something that is said about Israeli settlements, but it's not to be found in any of the treaties. Right? There is no treaty that talks about settlements. What are they talking about when they're talking about Israeli settlements? So when there are reports about Israeli settlements, what the Israeli government means when it says settlement, it means residential community. It means a particular kind of residential community. It means a residential community where Jews are permitted to live. Right? The Israeli government tends not to call residential communities in the West Bank or in Jerusalem settlements if they have no Jewish residents. They call them settlements if they're West Bank communities where Jews reside. Now, it's not solely Jews. There are some interesting stories, you can look these up. There are interesting stories in the media every once in a while about Arabs living in areas that the media calls settlements. For example, there's a residential community in a part of Jerusalem that was occupied by Jordan from 1948 to 1967. It's a neighborhood called Pisgat Ze'ev. Right? The neighborhood of Pisgat Ze'ev is, if you look at the media reports, will generally be called an Israeli settlement in East Jerusalem. The population of Pisgat Ze'ev is roughly 80% Jewish. The other 20% is Arab. Of the Arabs that live there, some are Israeli citizens and some are not. But uniformly, when you go and read reports about Arabs living in Pisgat Ze'ev, you will see these very interesting circumlocutions. They're Palestinians who live in a Jewish settlement alongside settlers. They will never be described themselves as settlers, because settler in the media is not a term that applies to a legal category. What settler means in the media is a Jew living in the West Bank, East Jerusalem, or the Golan Heights. That's the meaning of settler. And what then are settlement activities in the media? Again, these are not legal terms. These are not things which we can find a legal definition. What is a settlement activity? Well, that's the things that people do when they live in residential communities. Right? So it may be they build themselves a home, or it may be that their settlement activities consist of going down the street and buying some milk. That too, in UN reports, is described as settlement activities. Settlement activities are the things that Jews do in residential communities. Now, let's think about, what does international law have to say about this? Does international law tell Israel that it must forbid Jews to live in residential communities or buy milk or draw money out of an ATM in the West Bank or in East Jerusalem or the Golan Heights? It's very hard for me to even think about how you begin constructing such an argument. It's obvious that if there's international law on this, it goes exactly the opposite way. It goes the way that Doug alluded to in his memo also many years ago. Right? It's simply inconceivable to claim that international law requires denying people the ability to exercise residential rights simply on the basis of their national or ethnic group. But that's would be the argument here. That is what the argument here is. Right? So, does Israel have a duty under international law to? Does Israel have a duty under international law to prevent Jews from living in East Jerusalem, or the West Bank, or the Golan Heights? It's very, very difficult for me to even begin to see how you construct such an argument. In fact, if there's something in international law about this, it would seem to go the other way. And this is also something that Doug mentioned earlier. There are documents, not general documents, not general international law, but there are legally binding international law documents that talk about settlements of Jews. There's one in particular. It is the Mandate of Palestine, the 1922 document approved by the League of Nations. And it states in Article 6 that the mandatory is required to encourage, and I quote, close settlement of Jews on the land. And close settlement, that's about the only place you will find the word being used as a legal term. And there what the document says is not that there's a duty to prevent settlement. No, there's a duty to encourage it. Now, I'm not the first person to point this out. Doug was not the first person to point it out either. It's rather obvious. It was something that was pointed out many years ago by Professor Eugene, who was at the time the dean of Yale Law School, and was previously in the State Department. In fact, in the State Department, he was quite influential in shaping U.S. policy towards the aftermath of the 1967 war. But even he wasn't the first. And again, it's rather obvious. It's quite clear that that's what it says. And I might add that the rights of the Jews under the mandate were a big issue when the UN was formed. When the United Nations was formed, one of the issues that they had to figure out was what would happen to the rights of peoples that were protected by mandatory instruments. There were all these, Palestine was hardly the only mandate. There were many mandates. Most of them ended up either being dissolved or turned into this new form of protectorship, which they called trusteeships. But the British were not interested in putting Palestine into a trusteeship, and frankly, neither were the Jews there. And so there had to be some arrangement for these kinds of situations. And it was important to discuss this when the UN was formed. And there was a negotiation, and it ended up appearing in the UN Charter. So if you go to Article 80 of the UN Charter, thank you. If you go to Article 80 of the UN Charter, it states that, except as may be agreed in individual trusteeship agreements, and I will jump forward, nothing in this chapter shall be construed in and of itself to alter in any manner the rights whatsoever of any states or any peoples, or the terms of existing international instruments to which members of the United Nations may respectively be parties. So, Article 80 was written and drafted to specifically preserve the rights not just of states, but of peoples, thank you very much, but of peoples that had received in these mandatory instruments. Now, when all the dust settled, what were the mandates that existed to which this applied? There were two of them. There was Palestine, and there was Southwest Africa, which eventually became Namibia. Now, in the case of Southwest Africa, nobody doubts that the people of Namibia were entitled not only to the rights that appeared in the instrument, but they were unambiguously entitled to the rights of self-determination. And it's only somehow or another, when it comes to the Mandate of Palestine, which specifically said what it was for, right? It was for the reconstitution of the Jewish national home in Palestine in recognition of their historic connection. It called for facilitating the immigration and acquisition of citizenship by Jews and their subsequent close settlement on the land. Only there, all of a sudden, none of these rights appeared. Now, if it's clear, as it seems to be to me, that not only is Israel required not to interfere with the movement or the living of Jews in residential communities in East Jerusalem or the West Bank or the Golan Heights, and that it even has a duty to encourage them, then where's all this stuff coming from? Why would you think that settlements are illegal? And here it took quite an effort to twist a single paragraph in a single article in the Fourth Geneva Convention to give it an interpretation that is never received before anywhere else in the world and will never receive anywhere again. And it's quite clear that it is not a natural reading of Article 49.6 of the Fourth Geneva Convention. It says, nor may the state deport or transfer parts of its population into the occupied territory. It is not a natural reading to say the state, if it's occupied territory, must forbid people of a certain ethnicity from voluntarily moving to that area. Right? That is a thoroughly implausible reading. And it's no wonder that no one has ever used this reading anywhere else. It's not like this is the only case in the world where there have been claims made that the laws of belligerent occupation apply. Eugene mentioned one example. There are dozens. This is not an interpretation of 49.6 that appealed to anyone anywhere. Now, why is it that it appeals here? Now, I have to say that ultimately it cannot be taken as genuine. The funny interpretation of 49.6 to make it so that specifically Jews may not live there, to say that Israel has a duty under international law to cooperate with the Palestinian Authority's policy of criminalizing the presence of Jews in East Jerusalem and the West Bank, it's not intended to be taken seriously as a legal argument. It's intended as a subterfuge. It's intended as a rhetorical device to avoid saying what they really want. When people say that Israeli settlements are illegal, what they're saying is that it is unlawful for Jews to live in areas where the Palestinian Authority claims they should not live. That's what they're saying. And they're trying to say so in a manner that doesn't involve saying Jews can't live there. They're trying to say it in a manner that sounds like international law. Now, I have to close just by saying one last thing. This is not a new issue. And I have to make one minor correction to something that Doug said. It's been the law, more or less continuously, since the Turks first conquered the area in the early 16th century. It's been the law that in some form or another, Jews cannot buy land on the same terms as other human beings. That's been the law everywhere except when and where Israel has been controlled. And so that was the law in the Ottoman Empire. When the British conquered the area in 1917, they adopted Turkish Ottoman property law, kept it in force with some later variations, but they were capped ultimately by the land transfer regulations of 1940, which stated that it was illegal for Jews to buy property in 87% of the mandatory land. It was, as Doug said, unlawful for Jews to buy land in Jordanian-controlled areas. And the Palestinian Authority laws are adapted from the Jordanian laws. They've taken the Jordanian laws that made it illegal to sell and turned them into crimes. They've made it treason. Now, the only period in which there was relatively unrestricted rights of Jews to buy land just like any other human being were in those places controlled by Israel and when controlled by Israel. And I have to add, that's not the case today in the West Bank. In the West Bank, under the rules applied by Israel, it's not Israeli law. It is a military administration that uses Jordanian law and therefore, in various respects, continues to discriminate against Jewish property owners. It does so quite explicitly. Now, some of these you can understand. Like, for example, the regime there more or less outlaws private sales. And the reason is quite simple. The Israeli authorities are afraid of what's going to happen when the Palestinians start kidnapping land sellers and executing them in back alleys, which is what has happened. That said, what we are looking at when we talk about settlements is really an attempt to undermine a flagrantly illegal administration of a policy of ethnic discrimination against Jews. We ought not to be attacking settlements. We ought to be thanking Israel for, in this one respect, allowing equality to break through. Thank you.
Wow. As moderator, I'm going to take the liberty of opening up the floor for a few questions I have, and one at a time, and then I'll open it up to others. First of all, I'm not a legal scholar. I'm not even an attorney. I'm not a lawyer at all. But I did read the Fourth Geneva Convention, and one of the things that's stressed is the forced transfer of populations. I think you touched on that, Avi. I think the settlements are not something that the government of Israel has forced. Am I correct? But this is something where people voluntarily decided on their own, and sometimes the government of Israel supported them, other times they hadn't supported them. So it seems to me kind of insane that they're talking. I mean, I would love to invoke this about what Erdogan's doing in Syria today with the forced transfer of populations of Sunni Muslims and jihadists that are slaughtering the Kurds. But why is that? Am I wrong? Because I'm not an attorney. But
There is never been a situation in all the time of Israel's administration of the West Bank, East Jerusalem, or the Golan Heights, where any Israeli, any person whatsoever, has been forcibly transferred into the territory. I have cousins that live in various places in the West Bank. I'm not aware that any of them has ever been asked to move there, been told to move there, has been in any way given any particular incentive to move there. Nobody came out and said, here, we will give you a job if you go there. We will give you this amount of money if you go there. I will add, by the way, in most of the cases, they were born there. They're living down the street from where their parents lived, or down the road several kilometers. If you look at the figures, I believe that the number of cross green line moves in any given year is somewhere on the order of 2,500 people. And so we're not talking about transfers even in the smallest sense. Let's say we're talking about voluntary transfers. How many people are voluntarily transferring? They're not. Now, this is one of the things that, the Israeli government tried to point this out several years ago. They said there's this thing, they used a euphemism for it that I wouldn't use, right? They said what about natural growth? What they mean is, what about babies? Okay, are babies, if Israel allows a woman to give birth in the West Bank and she's Jewish, right? Should we see that as a violation of international law? Israel has transferred that baby by birth into the occupied territory. Now the answer for George Mitchell, when he wrote his report, was obviously that's a transfer. Right? We can't allow, good God, the Jewish population could grow in the West Bank. We can't allow people willy-nilly to have babies. But yeah, there's no connection that's even plausible between what's going on there and any sensible reading of the term transfer. It's why there is no thought of ever applying this anywhere else in the world. Can I cheat and take one more minute? There is one precedent for international law having to do with transfers of this kind. Not transfers of populations into occupied territory. It's in fact, it's the basis of Article 49.6. Okay? Article 49.6, if you read the notes, it says explicitly it's based on practices that were done in the recent war, that is World War II, and it's referring to a particular case. There's a case that was brought in Nuremberg. It's called the case of the major war criminals. There's a case against some fairly prominent Nazis. And the case was against their practice of what they called Germanization. Now, Germanization involved identifying areas where they weren't German enough, where the Germans would then eliminate all the lesser races, you know, like us. Then they would take people who had German blood, but since they were raised Polish, they were clearly not German enough, and so the Nazis would ship them off to retraining camp. And then when the pure Germans were left, and there weren't enough people there left to actually operate the community, then they would ship Germans into these areas in order to keep them running until the improperly trained Germans finished their re-education. That was the practice that was described in the major war criminals case. And they convicted them of the practice of Germanization. They didn't call it transfer, but it's very clear that that's what the article is based on. Now, what Article 49.6 is meant to describe, and again, I did not invent this. So you can look. There's a very famous book by Julius Stone of more than 40 years ago, in which he writes this. Says what it's clear that Article 49.6 describes is transfers that are part of a larger plan of what we would call now genocide. Right? Now, the idea of describing Israel allowing Jews to live in Judea and Samaria as part of a master plan for Nazi genocide is, excuse me, nauseating.
Yeah, I want to add that aside from the question of forcible, Article 49.6 doesn't use the word forcible. I think it's a bit of a red herring, because Article 49.6 talks about the occupying power transferring population. So it doesn't really matter if it's forcible. It talks about a situation in which a government is acting upon a people to move it. That is to say, the mover is not the people, it is the government, right? That is to say, the occupying power takes people and, whatever it means, transfers them. So if they've transferred themselves, they can't be transferred by the occupying power, voluntary or not. I think the case of the Erdogan plan, as it's known for Syria, Erdogan has published very openly a plan for moving about 2 to 3 million, a large number, people from Syria from Turkey into Syria. It's not clear whether it's voluntary or not voluntary. Actually, the United Nations High Commissioner on Refugees has actually certified, the plan's already begun, they're moving people, has certified that a significant number of these people are voluntarily moving. They have reasons to move. They're given some incentives, but nonetheless they've been certified as voluntarily moving. And despite the fairly extraordinary nature of this program, and its extraordinarily large scale, the United Nations reaction to this, the reaction of Secretary General Guterres, has not been, oh, that's transfer, forcible, not forcible, that is a serious plan worthy of further study and consideration. That is the official reaction of the United Nations. So I think that actually only underlines that.
Thank you. My next question is something that I almost regret having to ask, because I think it's going to mean more work for myself. And that's that just as President Trump had reversed the Obama policy about the communities in Judea and Samaria, or the settlements, what is to prevent another president, I could say a president, God forbid, Bernie Sanders or Elizabeth Warren, from reversing the Trump policy? Is there anything to prevent that? No. No, so, would you, all right.
I think that nothing prevents a future administration from disagreeing with what Secretary Pompeo said, more than Secretary Pompeo disagreed with what the Obama administration said, and President Reagan had disagreed with what the Carter administration said. So I think you could expect that if you have an unsympathetic administration, they will have a statement that contradicts what Secretary Pompeo said. I guess I have two comments on this. One is this administration has not yet elaborated on the basis for Secretary Pompeo's statement. There is no legal memorandum, even 4 pages long, that this administration has yet produced to support what Secretary Pompeo has said. He did allude in his remarks to a legal analysis, and I hope that the administration is going to present a serious legal analysis that supports what the Secretary of State said. I don't think there's any question that serious legal scholars acting in an academically rigorous fashion could produce a memorandum supporting what he said, and I hope they do that, and I hope that they publish it. What I would say is significant about what Secretary Pompeo said, especially if it's backed by a serious memorandum. What's significant is this. Until Secretary Pompeo's statement, numerous people who participate in debates about the Arab-Israeli conflict asserted that there is an international legal consensus of which the United States is a part that says that the settlements are illegal. And so this argument about consensus was a major element in news stories. If you Google news stories on this subject, over and over again, reporters say this, settlements are illegal as established by international consensus of which the United States is a part. Now, it's true that President Reagan contradicted the Hansel letter, but the Reagan administration didn't produce an elaboration, and it didn't produce a legal analysis. Now we have Secretary Pompeo saying a bit more than President Reagan did, but he also hasn't yet done a legal analysis. But if he produces a legal analysis, what that accomplishes is it makes it clear that there's no consensus. What you have, which is typical in the field of international law, is you have a dispute where some lawyers say one thing and other lawyers say something else. And if we can get to the point, I mean, you can't prevent a future administration from contradicting Secretary Pompeo. But what you can do, especially if there's a good legal memorandum backing what Secretary Pompeo said, is you can prevent any honest commentator, journalist, government official in the future from saying there's an international legal consensus in which the United States participates, because as soon as you have a serious statement by the US government that the settlements are legal, then even if a future administration contradicts that, there's no consensus. Then there's just, we have some lawyers that say one thing and some lawyers say something else. And that really, I think, qualitatively changes this whole matter. It no longer is a matter of consensus. It's like a lot of things in international law, it's a dispute. And I think that's really quite an important thing and a real accomplishment for this administration. But I think my personal sense is it would be very helpful if they did more than simply issue the statement that Secretary Pompeo issued if they back it up with a serious legal analysis.
Okay, I'm gonna open up the floor to questions now, yes.
To help this matter further, to promote this issue that the settlements are not illegal, there's been a lot of resolutions regarding Israel adopted by the Congress, be it on the BDS issue, be it on the two-state solution. Why don't you try to find some Congress people to propose a resolution that settlements are not illegal?
Right, okay. That is why I regretted asking the question. Because I think that work is going to be basically for me and EMET. But thank you, yes. And I think the truth of the matter is, at the way things stand realistically in the Congress, I could probably get it through the Senate. It would be virtually impossible to get it through the House.
But get it through the
But I'll
Senate.
get it through the Senate, and then we could at least have some basis.
It gives it more
Right,
gravitas.
Right. Yes, Phil, right.
Hi. Would it, first, thank you all so much. Two things. One, would it perhaps help Secretary Pompeo if an eminent scholars wrote a 10-page memo that would receive an A+, and it could be presented, and look, he can edit it, use it, not use it, but folks are busy, and maybe it would encourage, oh, well, this is a wonderful memo that we can release supporting this position. And so it's, and the other thing I just wanted to ask is if you meet someone in the street who's educated more by the media than this panel, and you have at most a minute, right? What little soundbite you find resonates the most that we could use? Thank you.
Like an elevator speech.
I think the administration is not lacking in good and useful material on the subject, and they have a memo. They have a document that they have produced. They have not released it yet, but they're not lacking for material. Yeah, I think it's important to cut through. No one actually cares about international law too much. I think it's important to cut through it. The legal framing of it is designed to distract from the essential issue. Are you saying that international law prohibits Jews from living in those areas from which Jordan ethnically cleansed them in 1949, that creates a permanent Judenfreie zone that must be enforced, was enforced by the Jordan and runs to all of its successors, that Israel must forever keep this area free of Jews, and if they choose to sneak in, they need to be kicked out, or life needs to be made onerous and difficult for them. That sounds illiberal, that sounds like apartheid.
I fully realize that what any president of the United States says has some weight internationally. But please, could you explain what the United States could propose to the UN? I mean, would it have to be a separate, couldn't the UN make a declaration? I mean, the U.S. could go to the UN. In international law, what would be binding?
Well, that's actually a very interesting question, and it highlights the difference between international law and domestic law.
Yeah.
And it highlights the fact that the term international law is something of a misnomer, because there are two things about domestic law that don't apply to international law. One of them is that in domestic law, questions have answers. In domestic law, if there's a legal dispute, it can be resolved authoritatively. In international law, that's not true. There's no world government that determines in an authoritative fashion what international law is. International law is often debates among lawyers. And those debates are never actually resolved. Now, sometimes they are by the consent of the parties, but a lot of disputes in international affairs are between parties who won't consent to some third party making a decision. And so the issue in international law doesn't get resolved. The other thing, of course, about the international law that's different from domestic law is that in domestic law, there's enforcement. There's there's a police force. So what you should understand, I mean, part of, we've made a lot of references here to international law. And it's just, the term international law is misleading for a lot of people because people are familiar with law in domestic life. A law within a government, law within a country that is governed by the rule of law. And so and when you call something international law, you think that it's law the way domestic law is law.
Okay. Well,
International law is not like that in many cases, and as I said, there's no ultimate authority to decide what the law is in a dispute in many cases, and there's no enforcement. So you should be careful. Now, you suggested, what about going to the UN? The thing that's important to understand is the UN is not a judicial body.
how,
The UN is a political body. So you wouldn't go to resolve a legal dispute to the UN any more than you would try to, resolve a legal dispute by coming to, a congressional committee. They're not in the business of resolving legal disputes. They're in the business of doing what they do.
okay, well, Dr. Feith, right now, the UN Commission on Human Rights is charging Israel with violating human rights.
Right, those are political,
Yeah.
they should be understood as what they are. They're political statements.
Well, if they're political statements and they plan to investigate, then what sanctions can they impose on Israel? Anything?
Again, they can act politically, and if you can impose sanctions politically, they can impose sanctions politically. It doesn't tell you what the law is. It's a bunch of people acting politically, making political arguments, and using political tools such as sanctions. But that should not be confused with the question of legality,
Okay.
where in the international sphere, you're not going to get a definitive answer.
Well, that's gonna have a lot of influence.
There are a lot
on
of questions on this.
international,
Thank you so much. There are a
what
lot of
people
questions. We have to
feel
go to someone else. Yes, sir.
about Israel.
I'm wondering if the Oslo Accords supersede the Fourth Convention, and if so, doesn't that moot the whole issue of occupation law, including Article 49(6)?
Thank you.
Yeah, so the Oslo Accords are very interesting in what they say about settlements. And they say this, more or less, the areas where there are settlements are under Israeli jurisdiction until there's a new agreement. And the dispute about settlements will all be resolved in this future agreement, whatever it is. And so if the Oslo Accords are what interest us, then it's fairly clear that you can come with no complaints to Israel about settlements, because the only thing Israel's obliged to do about settlements in the Oslo Accords is to agree to talk about them, which it has, and no doubt will again in the future. Right? Now, does that mean that there's nothing to talk about the Fourth Geneva Convention? Indirectly. Indirectly, because as Eugene said, what the Fourth Geneva Convention talks about is situations either of war or of belligerent occupation. And it's universally accepted, if one of the countries is not Israel, that upon the signing of a peace treaty, that's the end of the war, and that's the end of the belligerent occupation. And so, for those people who say, let's look at the Palestinians as if they were the party with which Israel fought, they're not. Well, let's say they are, right? Well, we got to a peace treaty with them too, right? Any way you look at it, Israel has a peace treaty with the other side regarding the West Bank and East Jerusalem. Any way you look at it, then, there can be no serious claim that the Fourth Geneva applies anymore, the Fourth Geneva Convention applies anymore.
Yes, Sean Ernst Camera. First, I'd like to thank you, Sarah, and Emmet for this wonderful panel. I can't believe that it's supposed to be here. I have a quick question and then also a comment. Question is regarding Jordan's occupation in 48-60. My understanding is that was recognized only by the UK and Pakistan. However, I've also variously heard that it's just the UK that recognized that. Pakistan did. So if you could clear that up for me. And then my comment, in brief, is that one important rhetorical point, I think, regarding selling land to me is that many of the Palestinian Arab leaders themselves, including the Husseini family, the Halidis, and so on, all sold land to Jews. So I just think that this is something that doesn't get talked about a lot, but in fact, these folks sold the land or they went to war for it later.
Just about the.
Could you repeat the question?
Yeah.
Yeah.
The question was, what was, more or less, what was the status of Jordan's occupation of the West Bank during 1948 to 1967? And then, that was the first question. You'll excuse me rephrasing it. Now, Jordan, after it conquered that area, claimed that the heads of all the big families in the West Bank had begged Jordan to please annex the area. And so the king of Jordan, being a magnanimous kind of guy, agreed and annexed it to Jordan. Now that step of annexing it to Jordan was recognized by Jordan and by Britain, which was at the time more or less in control of the army of Jordan. Now there have been publications that claim that Pakistan also recognized it, although there doesn't seem to be any historical evidence contemporaneous to that time showing that Pakistan actually recognized the annexation. And today it's all sort of irrelevant. Why? Because the Jordanians gave up their annexation anyway in the 1980s. They said, you know what, forget about it, it's not ours. So they never got it, and now even they admit it. That was the...
What was significant, though, is no Arab country recognized Jordan's annexation of the West Bank. It was considered illegitimate, even in Jordan's immediate family, as it were, which is the fellow Arab states.
Warren.
Yeah. What I don't hear in the conversation is still another dimension, which I'm not fully informed of, which deals with when Jordan invaded 1948, Judea and Samaria. It seems that there were a lot of Jewish communities, villages, and so forth in Judea and Samaria. And even if you go back in history, the New Testament talks about Jesus administering, walking through, talking to Jews and communities in Judea and Samaria. So what bothers me is that when we talk about, the pejorative word to me is settlement. When we talk about settlements today, how many of these are places which were villages containing Jews, community, city, whatever, destroyed, where Jews were killed, the cities, whatever, destroyed, Jews driven out. So in effect, it was made Judenrein by Jordan, yet many of these places, and I don't want to call them settlements, many of these places in Judea and Samaria, a lot of them, I suspect, are reconstituted Jewish communities, and therefore, how the hell can Jews be considered settlers in land which was theirs originally? And one of the, Shechem is mentioned in Torah, and what's today Shechem? Nablus, right? Does I have that right, Sarah? So this part of the argument goes beyond that legal argument, which a lot of people have trouble getting their hands around, but to me it's a more critical area because it goes back to the 1920s of reestablishing a Jewish state. I'd like to hear more discussion on that.
So I don't know why you don't like to hear them called settlements.
Boo.
No, I don't get it, because I think the upshot of all of our comments is there is no, it's okay. Settlements is not a bad word. There's nothing in international law against settlements.
That's how it's being used.
Well, that's a different
Israel
point.
has enemies, and they've established settlement is a terrible thing, and in relating it to Jewish occupation of stolen Palestinian land through the settlements.
Yeah,
So
I
far.
think that's
The media.
And the media.
That's to be resisted. I'll tell you where the word settlement comes from, as far as I can tell. And this is why it's unavoidable. Settlements seems to me, the reason they use the word settlement is because it's the English translation of a Hebrew term, yeshuv, which literally means settlement, and it is the Hebrew word for a small town. Anywhere you have yeshuvim in the Galil, you have yeshuv. You can't change the Hebrew language. These places are going to be called yeshuvim. There is no other way. They're called. That is to say, settlers call the places in which they live yeshuvim, as do the settlers in Galil, etc. Settlement is a fine thing. We don't mind, people settling in Texas, or, I took my family west and I settled in California. The settlement immigration is a normal human activity, and I think it's what's to be resisted is the notion that Jews settling somewhere. If you say people migrated from Guatemala and settled in Texas, you'll say, oh my God, it's an international law violation. We got to do something about that. So there's nothing wrong about. Now, if you call them a deportation or transfer center, that would be another thing. But there are, in fact, settlements of Jews. That's I think that's not an inaccurate description. The question is what one makes of that. And again, especially, but I would say not all settlements are. So maybe here's where we can agree. In some of the larger habitations that are more, which have the most ancient history, Hebron, Yerushalayim, the Jews have been there for indefinitely, and those are not yeshuvim. In Hebrew, there's a fairly strict hierarchy of words for different town sizes, and so those are not yeshuvim no matter what. Even if you settle in them, they're still not yeshuvim because they're cities. But if you settle in a little village, it's just going to be a yeshuv or a settlement, no matter what, and no matter where. That's the important thing. There's no political valence.
Let me just add two things very briefly. So you're putting too much on the Jordanians. It's true that the Jordanians did expel all the Jews who were resident in Judea and Samaria when they conquered those areas. But the Palestinian Arabs did a fairly good job in the 2 decades prior to that.
Hebron.
Right. So, for example, Hebron, there was a large Jewish community in Hebron that had existed since ancient times. It suffered a great blow in 1929 when their Palestinian Arab neighbors picked up axes and hatchets and went door to door to try to drive out the Jewish community, which they managed to do when the British decided to stand aside and let them do so in 1936. So, and it's not the only place. There were Jewish neighborhoods in Jerusalem that were driven out by Palestinian Arabs. There's Silwan was a Jewish neighborhood. Right? So there are lots of places. It's not just Jordan that where Jews were driven out by Palestinian Arabs, and that's an important piece of history to remember. Let's just very briefly on terminology. I think that Eugene is right. I have a friend who insists that we have to bring in a new term for Jews who live there because we don't want to call them settlers. Let's call them revenants. And I think it's very clever, but I don't know how many people, even after there was a movie, The Revenant, know what the word means. And so, of all the places I think it's worth putting our efforts, I'm not sure that's the best one.
Now, this woman in the red sweater has been keeping her hand up forever, please.
My question is, there have been a number of cases where the Israeli Supreme Court has ordered the removal of Israeli residents from areas that were, as we just said, were previously occupied, or where previously they were Jewish residents, and has ordered their removal. And I'm wondering what law is being applied in that case. Is it going back to the Ottoman, British, no Jews can buy land here, even though in those cases I understand the Jews actually bought property and were living there, as property owners, but were removed by the Israeli Supreme Court. What law were they just using policy, or were they actually using a law?
So Israeli land planning law is draconian, right? There's a Supreme Court judgment, and this has nothing to do with West Bank and anything controversial. They say, according to land planning law, if somebody wants to put a nail in their house, they require a building permit. Okay? You can do nothing until you get the appropriate bureaucracy to run and do all the things that it has to do. I'll add, it's not just land planning, it's also municipal planning. You cannot establish a municipality without a vote of the government. And so if you want to establish something new, some new community, you have to, it's a federal matter, right? It has to go all the way up to the top, and they have to vote yes. Now, the result is that there is everywhere in Israel, everywhere controlled by Israel, even places like in the West Bank where the Israeli law doesn't apply fully, it's very, very difficult to build legally. And as likely as not, when you run some new construction, the I's have not been dotted and the T's have not been crossed. And what's happening in these cases is more a function of the draconian and unforgiving nature of Israeli land planning law, and less a matter of adopting Ottoman, Jordanian discrimination against Jews. That said, there is politics behind enforcement priorities. Right? If everybody is building illegally, then who do you go after first is a big question. And Israeli authorities take a tougher hand with Jewish construction over the line in the West Bank than they would over Jewish illegal construction in, let's say, Tel Aviv.
Yes.
Okay, first of all, can you define revenant?
Something like returnee.
Okay. And the other question I had was the reason that Jordan was given statehood but not Israel by England just the fact that they were anti-Semitic in England?
Well, first of all, what happened was the British controlled, the British conquered the Middle East, and then the Middle East got divided into three main mandates: Syria, which included Lebanon, Palestine on both sides of the river, and Mesopotamia, which is now Iraq. And the British, for their own reasons, largely driven by the British military saying that there were manpower shortages and they didn't have enough people to maintain law and order in the very large area of Transjordan, which had about 350,000 people at the time, and was this vast area, most of which was uninhabited desert. The British military said, we cannot maintain law and order there. We don't want to send troops into there. And so even though it's under our mandatory control, we need to find a way to ease the burden on us of administering that territory. So what they did is they made a deal with the second son of the Sharif of Mecca, with whom they were allied in World War I, and the second son's name was Abdullah, and they set up a regime under the Palestine Mandate, an administration led by Abdullah to administer Transjordan. And they set that up in 1921, actually, even before the mandate came into force. And then what the British did is they amended the mandate in between the time when they drafted it and the League of Nations approved it. They amended the mandate to permit them to restrict the Jewish national home provisions to a subset of the territory. And so they added Article 25 to the Palestine Mandate, which allowed them to do that. They then told the League of Nations, we are restricting the Jewish national home provisions of the mandate to west of the Jordan River, that's when that is what effectively prohibited the Jews from settling east of the Jordan River. And what you wound up with is, until 1946, Eastern and Western Palestine were all under the British High Commissioner for Palestine. He directly governed Western Palestine, and he indirectly governed Eastern Palestine because the Abdullah administration reported to the High Commissioner for Palestine. In 1946, Transjordan became independent, and it went from being the emirate of Transjordan to becoming the Kingdom of Transjordan. Right? And so Transjordan became independent in 1946, and then it was in 1948 that the British said, we want to give up on controlling Western Palestine, and they left, and that triggered the war. So there were basically, they had two administrations under the Palestine Mandate, one of which was headed by an Arab, that was for Eastern Palestine or Transjordan, and then the Western one was headed by the British High Commissioner, he oversaw both, but he directly ran the administration for Western Palestine.
So who actually gave Jordan independence?
The British. The British released Eastern Palestine from the Mandate. Think of it this way: if there's a trust, the Mandate is a trust. If a trustee, and the British were the trustee, right? If a trustee has a bank account for, like a grandfather sets up a trust for his grandchildren, and the trustee is whoever it is, and the trustee decides to take the money out of the bank account and give it to the grandchild. You're independent. So the British, as trustee, gave the property that was in trust to the beneficiary in that case, which was the Arab administration, and they said, you're independent. And that happened in 1946.
Well, is there something more definitive in the treaty between Israel and Jordan in 1994 as compared? Oh,
wait, let me just. The reason the Brits didn't sign a similar treaty, the way they signed a treaty with the Jordanians in 1946, they didn't sign a similar one with Israel, a new state of Israel, for a very simple reason, because there was not a Jewish majority at the time. There was not a Jewish administration the way there was an Abdullah administration in Jordan. Now, why was there no Jewish majority? Because the British had spent the last 10 years keeping Jews out of Palestine. Right? So if you look at that as anti-Semitic, I do. The attempts to block Jewish immigration, particularly during the Holocaust. If you look at that as anti-Semitic, I do. You look at it illegal, I think it fairly clearly was, then yes, the British were treating them differently. It's there because of an anti-Semitic policy. But it's indirect, it's not direct.
Okay.
you're talking about the white paper.
Okay, first of all, we have to wrap up very soon, but before we do, two things. First, I have to thank this incredible, illustrious panel. Actually, three things. Second, I want each of you to be emissaries of the EMET, of the truth that you have learned here.
Yes.
And write, if you write, publish, you know, in your dinner conversations, please correct the horrible misconceptions, you know, the falsehoods that people say when they say everybody knows according to international law, but it's illegal, blah, blah, blah. So, you know, I ask each of you to do that. And third, I have to put in a plug for our next event, which is going to be February 4th, where I have some Iranian dissidents and scholars, and we're going to be talking about what's going on the streets of Iran today, and whether or not this might be a crack in the regime that we can. So thank you very much.